All counsel present. Mr. Tisdale's present. The jury's not in the courtroom. Okay. Ms. Yvonne said y'all have something agreed to.
Yes, so I emailed Leslie a copy of the instruction I would propose be read to the jury prior to reading the agreed portions of the policy then. So if we want to talk about that first, maybe that's a good place to start.
The proposed instruction, you mean?
Yes.
Okay, does the defense have any objection to this proposed instruction?
Judge, may I?
Sure. Now, while she's doing it,
Judge, we would agree to that instruction.
okay.
Yes, sir.
Let me have one of the party or that sign off on that
Sure.
for the state and defense. It doesn't matter to me who it is. Just
what's the date?
30.
Thank you.
Judge, we had agreed that the best way to do our agreed upon stipulation is just to highlight your copy with those 4 points that we have agreed to.
Okay, that's
Okay,
fine.
so if
I'll
you-
give them state or courts exhibit. I'm sorry, these are defense exhibits 2 and 3.
Excuse me. Maybe we should just go, I'd like to go through it on the record, and then maybe we could tell you what we agreed, and you could highlight it just so that you're comfortable reading it, you know what you did. Follow what I'm saying? We got to go through them all anyway, so when we get to one.
Okay, I'll do both. Let me have you sign. Okay. Let me have you sign.
Yes, sir.
Defense.
I'll borrow your pen, Judge. Thank you. Sorry. Let me get up with the pen.
All right, now, Mr. Backel, you want to see where she highlighted, so you're...
Sure.
And what I'll do is, if this is a portion you all agreed to, I'll initial it and date it today's date so that we know we agreed to what we agreed to.
Okay. So you want to start with 20.04 and just go through it, each one that they want. I guess the best way to do it would be to start on page 1 and whatever they want.
If I sit back here, Judge? Thank you.
Okay, the defense will identify which portions, starting with defense 2, General Order 20.04, which portions are seeking to use to impeach and which witness, identify which witness you make to impeach and the state response. Whatever you want.
Judge, we start with 1A, and I believe the list of witnesses that were given were Bennett, Wentz, and we'd like to add Sardis as well, Judge. I omitted his name earlier.
Deputy Bennett, Detective Newts,
Dietrich,
Sergeant respond.
1B, 1C, 1D, 1F, 1G, 1H. Judge State and defense have stipulated to enter 4, Roman numeral 4, notification of pursuit officer responsibilities, A through F. So those will be read by the court. The next section that we find applicable is section 8, conduct of the pursuit, subsection A as in apple and E as in egg. Subsection 9, termination of the pursuit, A, 1. A and 1. The next section is Roman numeral 12, subsection A, B, 1, and 2, and 5. We would also have wanted to include Roman numeral 15, glossary, which has a definition of the terms used within. And the signature of the sheriff.
That shows request on defense too.
Yes, Your Honor, that would complete our request.
States.
Okay, so I'm going to just say this one time, and it'll be my position relative to all of these, that the sole purpose is now evidenced by the fact that we have an agreed jury instruction, is to impeach the credibility of a witness. And that would be a witness who made a statement or offered an opinion that a particular thing was done, quote, in compliance or pursuant to policy and procedures. And my recollection from the testimony is the only person who referenced how a stop is to be conducted as it relates to potential policies, if you will, was Wentz. And again, I don't recall asking him specifically, was this all in compliance with policies and procedures, but if I did, to the extent I did, that's the point for which we're agreeing to this. So I start off with noting for the record that these are called general guidelines. And by definition, a guideline is not a mandatory requirement. It's not a must, but this is generally how they are to comport themselves. So quite frankly, I would argue all of these guidelines are subject to an exception by definition of the use of the term guideline. A, active pursuit must be considered a very dangerous act for suspects, the deputies of the general public. I cannot see how that, I don't remember anybody saying that particular policy was followed or whatever the case might be. I guess I don't need to make them all, do I? Okay. So anyways, that relates to all of those in I, A, D, C, D, F, G, and H. Again, I don't think they impeach anybody. I think they are irrelevant, extraneous, and inadmissible. I agreed to the notification of pursuit, and I did so because it's Roman numeral 4. To the extent the jury thinks that Detective Wentz's testimony was everything was done absolutely by to the letter of the policy, then that's something they can consider in weighing his testimony.
Let me stop you there so I'm clear. They requested A, B, C, D, E, and F under Roman numeral 4.
And we're not objecting to that.
Okay, so for the record, I've highlighted that portion of that exhibit from my initials just to be able.
Oh, I'm sorry. Yes, so 8A, we object to that. Again, we don't think there's anything that impeaches the testimony of any particular witness. E, we object. 9A and 1, we object, and we don't think that impeaches anybody's testimony, any of the witnesses they've identified. That takes us to Roman numeral 12, forcible stopping. We object to A, B, 1 and B2, as well as 5. any specific witness. And for the record, I would note that the defense has launched a general objection, meaning all of these officers clearly in good faith, they cannot believe that each and every one of these provisions would impeach the testimony of each and every one of those officers. So I'm arguing that their objection for the record, or their position for the record, is insufficient to enable either this court to make a well-reasoned, intelligent ruling, or for the team to make a well-reasoned argument. And then finally, 15, entitled glossary, which is a basically definitional section, we would object. I can't imagine how that could possibly impeach anyone. So that's our position on that.
Is there any comment on defense?
No, yeah.
Defense 3.
Defense 3 identified as the County Sheriff's Office General Order 20.05. We would seek to introduce Roman numeral 1, letter C, number 4, entirety, A, B, C, and D. Roman numeral number 2, subsection A. And this section, Judge, state has agreed with A2 and A3A. So it would be Roman numeral 2, subsection A, number 2, and number 3A.
But we're not, it's just, we're agreeing for you to read where it starts traffic stops, not the Roman numeral 2 vehicle stops. You didn't ask for that. You want the traffic stops, radio communication, initiating stop, and positioning of the vehicle.
That's correct, Judge. Also number 4
Okay.
has been agreed to.
Hang on just a minute. All right. Under Roman numeral 2, the state defense are agreeing to which is radio communications.
Yes, sir.
A3, which is initiating stop. All 4 paragraphs designated A, B, C, and D.
No, sir, just A.
States agree with A.
Yes.
Okay, I'll highlight those portions. Just a minute. Initial, that dated in today's date, the statement is correct.
Your Honor, we also agree as to number 4, positioning of the vehicle.
State agree with that.
Yes, Judge.
I'll highlight that on my copy. We'll initial that with my initial dated today's date. Okay.
Your Honor, we would be seeking to introduce under number 2, A, 5, and 6. Those are not agreed upon, Judge. And finally, Judge, under Roman numeral 2, section B, felony stops in its entirety. That would be 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10 in the state of Ohio. That's all.
Okay, so I would, without restating all of my previous statements and objections, specifically renewing my objection to the vague nature of the defense position, as I don't know to which of these witnesses any of these particular policies would tend to impeach, and therefore I'm incapable of offering a thorough and well-reasoned objection. I state first my objection to, I guess it started in Roman numeral 1, subparagraph C, 4, A, B, C, and D. I object to those. I do not think that they tend to impeach any of the witnesses as indicated by the defense. That takes us to page 4, which is vehicle stops. Again, the court, as the court is aware, the state agrees the court to read subparagraph A, traffic stops 2, 3A, and 4. We object to 5 and 6 on the basis, again, that it does not impeach the testimony of any particular witness as improper impeachment by way of extrinsic evidence, which is an objection that I would proffer as to all of these issues that we've been addressing over this period of time. Felony stops on page 5, which would be B1 through 10. Again, we would object that this does not tend to impeach the testimony of any of the witnesses. And I don't know which witnesses it would be applied to. Again, I would say that it would be improper impeachment with extrinsic evidence. And of course, to all of this, including, I might add, although I'm stipulating, but to all of this, I'm not waiving my initial original objection that it's not relevant. So I think that was all.
Sustain that objection.
Right.
Judge, I would just add 16 and 14 amendments. I would just add, Your Honor, to my objection to not being allowed to present this evidence under the 16th and 14th amendments, Your Honor. Thank you.
So let me make sure I understand the procedure. After I read the stipulated instruction, then read the highlighted portions to the jury, then have the defense announce they rest, state announce y'all had a rebuttal, advise the jury that close that evidentiary portion of the trial. Is that y'all's understanding?
Yes, ma'am.
So, yeah.
Now, she should have. Just have her from this thing. Now, Mr. Tisdale, before you change your mind about whether to testify or not, but one of your lawyers will be no if you do, okay? Understand the word about prove you can do it, but if you change your mind, please let me know. All right. I find, at least in my conversation with Mr. Tisdale, his waiver of his right to testify in this proceeding is knowingly and voluntarily made, understands his rights, to exercise his right not to testify. But if you change your mind, let your lawyer will know. She's printing them out. I'll get there with us just a minute. She'll bring them together. Oh, well, I got you here. It's 3.370 deals with sequestration issues. The rules, I recall, used to be required sequestration. Now it doesn't require it. If both parties can waive it. Right? I recall that.
That's correct.
If neither side, if one party wants to sequester them, I'll waive it. So, you don't want to think about it, you want to decide, talk about it now.
Sure.
We talked about it earlier. We think that depending on when the jury gets the case, if we're going to go closing today or we're just going to charge it today and start closings tomorrow, we don't even know if we'll even get there. To worry about.
When we get it, I don't know when we'll get there.
Yeah. So.
The reason I ask is I got to start making arrangements.
Yeah, we kind of believe, we're under the belief that we're going to be waiving that.
And we would waive it as well. So I guess why don't we talk about it? I mean, it seems to me that we haven't got the jury instructions done yet. We've got to resolve these final issues. We certainly would have no concern about sequestration. I think if we start closings tomorrow morning and by the end of the day, we hopefully will have a verdict. I don't think the closing is taking that long and jury instructions either. So if we can agree now that we're going to just do closings on Thursday, that seems to make the most sense.
We've been great, Judge.
Okay, well, that's all fine with me. Both sides agree to waive sequestration. But if either side changes their mind, which I'm free to do, this Friday, we're going to have a court I reserve the right to let y'all present your argument. But I reserve the right, if y'all change your mind, to hold off on instructing them and beginning their deliberations until Monday, because I don't want to be in a situation where I'm going to be here and they're sequestered and all that kind of stuff. So if both sides are waiving sequestration, it's not an issue. So if y'all change your mind, let me know.
Yeah, I'm not changing my mind.
Okay. You can't, just let me know.
I never change my mind. Even when I'm wrong, I don't change my mind.
She's printing out, don't just bear with us.
There's just one last issue that's just for housekeeping purposes, Your Honor. For the trial, they had done a motion to compel the FBI video. The state, you had then later ruled that it was work product, but we had asked that the video be admitted into the court file as an exhibit for appellate purposes. We're just reminding the court of that as a housekeeping matter. It still has not been done.
Okay, I'll make sure it's done before.
Thank you.
All right, as soon as she's done printing, we'll bring it in.
I'm sorry, Joe. I've been spending all morning while coaching on the arguing with the other matter, going through the jury instructions because I didn't know what schedule we were going to insist on. I'm almost done, and I usually when I try cases in the back of all these countries.
Okay, well, if you don't need a paper copy, I'll make one for you. If you don't, okay. All right, we'll finish looking through them. You let me know when you're ready, okay? Okay, we'll just go off with it. I'll look through them too.
out a updated version. I'll call it Jury Instructions 2. It will include the firearm aggravator. It will remove defendant testifying, and it will change from red to black, defendant not testifying. I put them in red because I didn't know what was going to happen.
All your color selections.
Yeah. Do you have computer access up there, or would you rather have it to the front?
She does, or you can send it back to the house.
Sounds
call and say, as soon as something goes on,